Hey guys, let's talk about what happened in the Alex Jones case in Connecticut and what's going on with the cases against him. So I think everybody knows at this point that a verdict was rendered and the plaintiffs were granted a judgment in an amount just under $1 billion for their claims against Alex Jones. So what's the status of that? How did that happen? What's going on? Let's go over that. Like what happened in Texas, the judge in Connecticut defaulted Alex Jones and the other defendants, saying that based on your discovery violations and the inability to curb your behavior with less severe sanctions, I'm going to exercise the nuclear bomb of sanctions, which is striking your defenses and finding you liable. And that's what she did. It's the same thing pretty much that happened in Texas. Should that have happened? Some supporters say he meticulously complied with all discovery requests and demands. Others say that he didn't and it was a pattern of misconduct. The judges clearly landed on the side of a pattern of intentional misconduct by the defendants. Is that true or not? Well, they can appeal it if they don't agree with it. Do I like it? I don't like it. Okay, I'm not an expert on exactly what went on in discovery, and I know pretty much all the people who make comments on it aren't either. But it is, you can appeal it, right, because it is such a severe sanction. Having said that, I would far prefer that in both these cases that if the case were tried on the merits. Generally, any defendant should be able to try a case on the merits and be afforded their defense. And especially in a high-profile case that involves First Amendment issues, right, it might involve a First Amendment issue where the decision is the First Amendment doesn't protect what he does, but that's a decision on the merits. It also, if for his supporters, could have involved law that would be favorable to him. But we're not going to get that analysis either way because those issues were foreclosed in both of these cases. So when the jury sat in Connecticut, they were there only for the purpose of how much damages were suffered. The judge instructed the jury that she had already found the defendants liable for the conduct.
The defendants have been found liable for the following violations of each plaintiff's legal rights: defamation, intentional infliction of emotional distress, false light invasion of privacy, and violation of the Connecticut Unfair Trade Practices Act. I will define each of these shortly. It is your duty as jurors to determine the extent of damages. You should award those damages you find to have been proven by a preponderance of the evidence and as I further instruct.
And she instructed the jury that she found that Jones's conduct, I'm just going to refer to him and not the other companies, that his conduct was the proximate cause of the damages that the plaintiffs suffered. So crossed all those bridges and the only one left was how much? So this is a tough situation, a tough call for either jury. How do you decide how much it's worth? If the judge has told you that he lied about these people, said these things about these people, and that he's liable for those actions, and that is what the judge did, whether you agree with her or not, you're left with the task of listening to the evidence and saying, well, how much damage did that cause these people? Because that's what you're supposed to do. So I'm going to look at the compensatory award, not any punitive award. There was one in Texas, and I think there will be one in Connecticut. It's a whole different calculation. Each state, everything's always different. But on compensatory, the logic is very similar, which is to the degree that you can and that money can do it, you should put the plaintiff into the position they would have been in if the defendant had not engaged in the conduct. So obviously that's really easy, say in a car wreck case where no one's hurt, because you just look up the value of the car and you give them that money or you give them the repair cost. That's pretty easy. Or you're out of work for a week. Well, how much money do you normally make in a week? And we'll give you that amount of money. This is different because this is a non-economic kind of damage. This is assessing how much it's worth to have suffered mentally, either your reputation loss or the emotional distress that was found in this case. What is that? And clearly, the remedy of a money judgment, it doesn't mean you don't have emotional distress anymore. Okay, so in a car wreck case, you damage my car, you buy me a new car, hey, I'm pretty happy. I'm back where I was. If you say something horrible about my family and defame me and cause me emotional distress and cause people to threaten me, which is what was alleged in this case, and then you give me $1 million, I'm probably still afraid, right? I still feel bad about this whole thing. So money is no real remedy for this. Now, on the other hand, you can't say, well, money's not a remedy, so we won't give any money, and then you just let people do things to people to cause them emotional anguish. So money's pretty much the tool that is there, and that's what the court's going to use. But it is an imperfect remedy for sure. How do you value it? So they're going to tell the jury, and she did tell the jury, that you need to come up with a number that's fair, just, and reasonable. And you need to do it based on your common sense. And she says there's really generally not a mathematical formula you're going to be able to use. You're just going to have to listen to the evidence and figure it out. Well, that's extremely imprecise, right? That would be like in the car case. Okay, you damage my car and no one can testify to what any of these cars are worth. And the jury just has to kind of guess at, well, it was a good looking car. It was kind of new. Maybe it was a little bit old. I wonder what that could be worth. Who knows, right? You would normally put on evidence of the value of the thing that you're trying to get an award for. You can't really do that in this case. There are some actual damages you could, therapy cost, an alarm system or whatever, something like that. But the general emotional distress, how do you capture a number for that? And to me, certainly in both these cases, the plaintiffs were very loose on that and were, to me, treading more to the, this guy's awful, hit him hard kind of logic versus here's an amount that equates to what these people suffered. So however you choose to see it, that's really what was going on in these cases. And to me, it's hard to escape the idea that there was an element of punishment in the Connecticut awards just because the number is so high. That's just my opinion. So in Texas, pretty much the average award per plaintiff on the compensatory damages, not punitive, was about $2 million. In Connecticut, same actions is well over 60 million, like $64 million average per plaintiff. So when you have a legal system where you have a similar kind of damage can generate a result of either 2 million or 64 million, that seems like maybe that's a system that has an issue with it. But it's not particular to Alex Jones' case. Just the measure of damages for emotional distress kind of things is tough. So what happens with this? One interesting aspect that's different than some other cases you've seen is in Connecticut, if you file an appeal, there is an automatic stay on the judgment. You can't go collect it. So there's none of this suspension bond drama that people were worried about in Virginia, that sort of thing. There's a stay, so they can't go collecting his assets as long as this goes on appeal. Now, of course, you can ask the Court of Appeals or, under certain circumstances, the trial judge to lift that automatic stay, but you're only supposed to do that in Connecticut if the appeal is really for delay or if there's some super requirement of justice or that sort of thing that requires it. And I think it is fair here, even if you despise Jones and his conduct and think that the number is fair, that it's a fair situation for him to appeal that because he was defaulted. The number is so eye-popping that this is no frivolous appeal that he's going to be filing for sure. He may lose, but it's a worthwhile appeal, absolutely. So what about will he lose? Well, the default judgment, I'm not going to go into that because it's over the level of sanctions that are available for discovery, and that's kind of a technical issue. But the number on the damages. So because these kind of damages are kind of speculative, there is a notion in the law that if it's excessive, clearly excessive, not based on any evidence or whatever, the court can remit the damages award. They can reduce it. Will the judge here do that? No. I mean, assuming they have that motion available in Connecticut, but I would not see this judge doing it, however, because she seemed have no issues with the judgment at all, just from body language and the way she was expressing herself during the reading of the judgment. And during the trial itself, I don't see her having sympathy for Jones. I can only see a reason for her to remit it if she thinks that if she doesn't do it, the Court of Appeals could throw the whole thing out and say you got to do this trial again because of these flaws in it that led to this kind of a verdict. But I don't see her buying that. So I don't think she's a solution for Jones. I doubt her attorney thinks that either. So it goes up to the appellate level. Will they do that? If you look at case law around the country, there's certainly an argument that based on the evidence that was presented in this case, that you can't support these numbers. However, there's also a case law that says, look, are we going to leave it to the jury or are we not leaving it to the jury? I mean, what's the story here? It's up to them to decide the level of trauma in any particular case. And judges are human, even appellate court judges, and that's why there's this notion that sometimes bad cases make bad law, that sometimes if the situation appeals more to the emotional side of the judges, they'll figure out a way to justify it. And Jones is not a sympathetic defendant to most people. To his supporters, he's very sympathetic. But if you haven't figured out yet now, if you are a supporter, that there are a lot of people on the other side of the fence, you're not watching what's going on. And even if the law might say there's a good argument to reduce these damages, there's also a chance that on the equity side of, not for this guy. So that could play into it too. I mean, who really knows? But that would be an argument on appeal for certain that this level, this magnitude of judgment exceeds what the evidence could possibly support. There was no testimony that could have supported any of these numbers, and so it was clearly excessive. So it either needs to be reduced or we have to do this trial again. And there are cases, at least in other states, where that's occurred, and then the Court of Appeals will say, well, there was this kind of an argument that occurred that influenced that, or the judge's unclear instruction, or they'll give some reasons and say that contributed to this ridiculous verdict, and we're going to have to do it again. So that could occur. I would not gamble $1 on the Court of Appeals throwing out his verdict. But at any rate, it's going to be suspended on appeal, the collection of it, unless they get the stay lifted. But let's say the appeal is finally decided or something like that, then what happens? Then you get into all the mess that you have everywhere else, which is there's no money waiting for you just because you have this piece of paper from the court saying you have a judgment. You have to go get it. And in this case, I think the plaintiff's attorneys have already said, look, we're already active in Texas trying to find out where his assets are, where he's moving money around so that we can get after those when the time comes. So that's what they would need to do. And again, harken back to the Depp versus Heard case. Johnny Depp gets this judgment for $10 million. There is no suspension bond filed there, and there is no automatic stay there. He could then conceivably begin to collect on his judgment. But to do it, he's got to go to where she has assets. California, she's not even in the country right now. Does she have assets here? So it's not easy to go get this money. And for all the money he's made, I don't think Alex Jones has $1 billion sitting around. And whatever money he has sitting around, he will probably either already has or will be trying to get it into a situation where it's the most protected it can be from collection and the legal process. So it's no clear path to getting this money. But at the end of it, I watched this trial and I watched these families who had a horrible nightmare they went through when their children were killed. And then Jones misrepresented the situation to people. Sorry, he just did. Yeah, I know later on he said, yeah, I was mistaken about that. But during the course of it, he said awful things about these people. And certainly having awful things said about you and your child after your child was murdered contributes to some degree to your distress. They're not making all that up. So there's an element of relief for them that what the jury did with these kind of numbers, similar to Texas with the punitive award, that they spoke to these people and said, we feel the pain that you went through and we are sympathetic to that. And that's a good that comes out of this. That is, to some degree, a function that occurs when you get a jury verdict one way or the other. I mean, look in Florida yesterday when they gave life sentence to the shooter at Parkland, how devastated the families were at that conclusion by the jury. They felt that they were diminished and dismissed to a large degree in the process. And that's unfortunate. I hate that. So the opposite occurred here, and that's maybe the silver lining out of this, because it is a complicated legal situation. If you like Jones, or if you think this was an infringement on free speech, I understand that too. And I am disappointed that the case didn't proceed on the merits. Maybe the appellate court will at least address to some degree some of those concerns. I don't know. That would have to get into the technical side of the discovery issues to do that. He will have his day in appellate court, and maybe even in front of this judge in terms of discussing the amount of the judgment, to say this is too much money or that the trial was conducted in a wrong way. He will have his appeal, and his attorney says that they are going to file an appeal. And when you have a judgment like this, if you can afford it, you certainly should file an appeal. So the case isn't over, but that's what's going on with it. A gigantic award, way different conceptually, completely, than the Texas award, and a whole different process up there in Connecticut, but the result being the same, but on a different level of magnitude. So we'll see what happens with this horrible episode for everybody. Thanks, bye.